Hi, my name is Zak Goldstein, and I'm a Philadelphia criminal defense attorney. Today, I'd like to speak briefly about federal felon and possession charges. This is an area that we've really been seeing an increased focus on by prosecutors in the United States Attorney's Office for the Eastern District of Pennsylvania. There's been a lot of dispute recently between federal and state prosecutors in terms of who should be handling these charges, what the penalties for these crimes should be, and how much time in jail prosecutors should really be seeking. This is an area that typically was handled by county prosecutors in the Philadelphia District Attorney's Office, which normally has jurisdiction over cases where there was an arrest by the Philadelphia Police Department. But recently, given sort of an increase in high-profile shootings and a sense from federal authorities that the city is going too easy on these charges, we've seen more and more cases being picked up by the feds, adopted, and then prosecuted in federal court, even where the arrest was initially made by the Philadelphia Police Department. The bottom line is that possessing a firearm is a serious felony both under state and federal law. Pennsylvania makes it illegal to possess a firearm if you have certain prior criminal convictions, and that's what's called a violation of the Uniform Firearms Act under Section 6105. Now, that has become a felony of the first degree, but there are no mandatory minimums for that charge, meaning that we have often been able to negotiate sometimes even county sentences or short state sentences for clients charged in the Philadelphia Court of Common Pleas. Now, federal law has a similar provision under 18 U.S.C. Section 922G, which also makes it illegal for certain people to possess a firearm under federal law, in addition to the state charges that you could face if you're arrested in Philadelphia. For example, if you have a drug addiction, if you're in the country illegally, or if you have certain prior felony convictions as defined by federal law, then it becomes not just a state charge under 6105, but also a serious federal charge to have a firearm when you're not allowed to do so. Now, in general, you have to look at the actual list of offenses to determine whether or not you're eligible to have a firearm or not. But the general rule is that anything punishable by more than a year in jail that's classified as a felony, or anything that's classified by the state as a misdemeanor but is punishable by more than 2 years in jail is going to make you ineligible to have a gun under federal law and potentially trigger criminal liability under this section. So it can be a confusing statute in terms of exactly what makes you ineligible, but the bottom line is that any felony offense under state or federal law, any misdemeanor of the first degree in Pennsylvania, some other misdemeanors, including domestic violence offenses, all those things are going to make you ineligible to possess a firearm and potentially could lead to serious charges if you are arrested either by federal authorities with the ATF, Homeland Security, or the FBI, or if you're pulled over by the Philadelphia police or state police. It is possible for federal prosecutors to exercise their jurisdiction and adopt the case and pursue it in federal court. Now, in order to prosecute this charge, prosecutors would have to show four things. First, they have to show that the defendant possessed a firearm. Second, they would have to show that the defendant was prohibited from possessing a firearm due to a prior conviction or some other disqualification. Third, they would have to show the defendant knew that he or she could not possess a firearm due to that disqualification. And fourth, that the firearm was in or somehow affected, that there's some sort of link to interstate commerce. So it's really important, if you're facing charges, if you're under investigation for a violation of this statute, to look at all of these elements, to look at all the evidence, to figure out exactly what in your background might be triggering this disqualification or making prosecutors think that you're ineligible, because sometimes it turns out that that's not really the case. But at the same time, there are people who have old juvenile offenses or old misdemeanors that they don't really remember or understand how those things worked out, that can then result in a serious federal or state criminal case for possessing a firearm illegally. Now, there are defenses to this charge. The first is that in every case, prosecutors have to show that you had a gun. They have to prove it beyond a reasonable doubt, whether it's a trial with a judge, a trial with a jury, a preliminary hearing. They're going to have to prove that the defendant actually possessed a firearm. And that's not always so easy. If it's a case where there's a gun in a car, it may be that the defendant was borrowing the car and didn't know that someone else had left the gun in there. If a gun was found in a house where you're staying, but other people live in the house. It could be that somebody else owned that gun or possessed that gun. It's not always so clear that the person charged, even if they were near the gun, actually knew about it, actually had control over it, that it was their gun, that they constructively possessed it. Second, even in cases where you've got a gun on you or the defendant has a gun on him or her, the police still have to show and prosecutors still have to show that the gun was obtained in a manner that complies with the Constitution. So there could be a motion to suppress if the police conducted some kind of illegal search, if the agents conducted a search of a house without a warrant. Those could be things that could lead to the gun being suppressed and the charges dismissed. The police cannot just search you on the street or frisk you because they want to. They can't come into your house without a warrant or without consent. They can't necessarily search a car just because there's been a traffic stop. These are all potential defenses to these charges. And then third, there's some other things that come up, whether or not the object is really a functional firearm that meets the definition of the statute, whether or not the defendant really knew that he or she was ineligible to possess a gun, whether there's really that link to interstate commerce. These are all things that we would look into in this type of case whenever there's a charge, either in state court or federal court, for being a felon in possession of a firearm. But the bottom line is that even a first offense can be punished by up to 10 years in federal prison. There are extremely serious mandatory minimums if you have certain prior convictions. And so if you're under investigation, you're facing charges, you need a criminal defense attorney right away. We offer a free 15-minute criminal defense strategy session to each potential client. So call 267-225-2545 to speak with a defense attorney today.